Okay, in this part of the lecture, I'm going to look at specifically the International Criminal Court, or rather the topic on international criminal law. And the purpose of looking at the ICC and also more specifically the international criminal law is to elaborate a little bit more on the various ways in which the international community is adjudicating cases. And I hope by now you all understand the word which is about adjudication. That is, when there are any legal disputes that arise, how does the international community deal with those legal disputes? And this is very important because ultimately, as I've been saying, we are looking at how international law and the work of international organizations can facilitate the uh, uh, you know facilitate greater cooperation among member states. So one important and interesting arena where international law has rapidly developed, or more specifically accelerated in the 21st century, is in the arena of international criminal law. Now, when I use the word international criminal law, what I mean to refer is how the international community is trying to hold individuals accountable for their actions. And as one can expect, the international community will only try to adjudicate or hold individuals accountable for grave and egregious crimes, not for, say, possibly for some economic crimes or other crimes, although they might be having similar impacts. And as I mentioned, the international community and generally people respond more when there is harm to the individual human body um, than, say, an economic loss. So, this is one area where individuals are being sought to be held accountable. And, we can take a look at it by focusing on the International Criminal Court, which has been established by uh, through the Rome Statute. And it came into force, if I'm not wrong, in around 2002 or 3. So, what the court does is look at four major crimes which are listed here: war crimes, crimes against peace, crimes against humanity, and the crime of aggression. And these become the focus of, holding individuals accountable. So, the uh, title of this particular part of the presentation, which is on which says Nuremberg to Rome, points out to the first effort by the international community after the end of the World War II to hold individuals accountable for their actions. And you might have heard about the individuals being held accountable, especially those uh, of the Nazi regime in Germany and also officials in Japan. So Nuremberg was the place where an international military tribunal was established, and as the nomenclature itself suggests, it was a military tribunal. And similarly, a Far East tribunal, again a military tribunal, was established. Sorry, here it was different. It was it's a Far East tribunal, and here it was a tribunal which consisted of legal experts, and although it was guided by the military leadership of the US in Japan at that time, it still was a far more balanced judicial body. And uh, so we'll run through some of these efforts. If we look at the various international efforts to hold individuals accountable, this is a suggestive list. Um, One with looking at the International Criminal Court, 98 Rome Statute, and coming into force in 2003. A few temporary international criminal tribunals established. One, I mentioned the International Military Tribunal in Nuremberg, ICTY and ICTR, the International Criminal Tribunal for Yugoslavia, and ICTR for Rwanda, were established in mid-90s. There were certain other internationalized criminal jurisdictions, which were after in Kosovo, East Timor, Sierra Leone, and Cambodia. Um, Sometimes these are referred to as hybrid courts, and then there have been efforts in individual in countries where the which have been called as examples of national exercise of universal jurisdiction. And I'll elaborate in a minute what universal jurisdiction is. But say, for example, in 1961, Adolf Eichmann was a Nazi official who was arrested and by Israel and taken, if I'm not wrong, from Argentina and taken back to Israel and held accountable for the crimes he committed and sentenced to death. Similarly, in 98, Augusto Pinochet of Chile, he was sought to be arrested in Britain on the basis of a request by a court in Spain. And the manner in which this happened was that some Spaniards were killed during the Pinochet regime in Chile. It was mid 80s to early 90s under the military dictatorship. And the Spanish courts took cognizance of their citizens being killed. Then they wanted him to be extradited. And Pinochet was traveling in Britain at that time, and they sought cooperation from Britain to send him back. That did not happen, but he was sent back to Chile, where he was tried by Chilean courts for his military dictatorship. And sadly, though, he died before justice was applied, or in a way. And so similarly, other cases have been happening. And then certain examples of national application of domestic law involving certain international crimes have been also taking place. So an example, is the military junta, which in Argentina, which again during its dictatorship committed severe crimes and were accused of committing certain international crimes, and then they were held accountable in their domestic context only. So these are some efforts where severe crimes have been sought to be addressed by the international community. And why we might need the International Criminal Court? Simply put, I think we, there are growing incidences of violence, and more specifically, in terms of violence happening at the like in genocides. Now, I think Syria, the plight of Rohingyas in Myanmar, and so we need to take a look at it. And here's some history, which is in terms of the International Legal Law Commission taking up the matter. Ad hoc tribunals being established by the Security Council in mid-90s is one thing, and they realized that they need to establish a permanent court, and that is where the international community decided, and in 98 were able to agree upon the Rome Statute, which was open for signature and came into effect in 2003. You might know that India is not a party to the Rome Statute, and on the matter of India not being a party to the Rome Statute, we can explain in a kind of a simpler way, but also very pertinent, which is India is very cautious about ceding aspects of traditional sovereignty, and so that is one reason why we have essentially excused ourselves from permanent jurisdiction of the International Court of Justice through a declaration and reservation and declaration. And similarly, we do not join these various international arbitration tribunals. And you might be wondering, oh, we are part of the WTO, which has a binding international court. That is true, but the WTO came as a package deal. That is, either India could be in it or not. And I think this was a choice. There was very limited choice there, but there is no penalty here, so to say, if India doesn't join the Rome Statute. So they remain out of it. This is some kind of the detail in terms of some of these people who who are meeting in Rome and then enacting. Here is a picture of a person, Benjamin B. Ferencz. He was speaking at that particular Rome treaty discussions, and incidentally he was a prosecutor at the Nuremberg trials. So that's after war, and he was part of what we call as a judge advocate uh, 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 general part, which is the JAG or JAG in the military parlance, and he was a prosecutor at that time. So he made an appeal, and that is something just to highlight a few people. And why it is important? The idea is centered around some of these aspects. One, deter future war criminals. Two, promote universal justice, end impunity, help end conflicts, remedy deficiencies of some of these ad hoc tribunals, and also, finally, and very importantly, complement national judicial systems. Now, here is the where I want to elaborate on universal jurisdiction. Today, there is a case being made by the international community that when faced with such egregious crimes against individuals and in people, the international community has a universal jurisdiction to address these matters. By that I mean that uh, uh, all countries should take steps within their domestic jurisdiction to, in a way, universalize all of these crimes, which I'm going to elaborate in a few minutes, and that they should then, wherever they find such criminals, accused criminals, they should try to hold them accountable. So, although there is appeal in your universal jurisdiction, I think it can be easily politicized, and not so surprisingly, the US, India, and China, of course, will are very vehement against such universalizing kind of jurisdiction. What these judgments can seek to do is also try to kind of identify certain solutions through after having uh, uh, sorry along with a international adjudicatory processes. I think other solutions like sanctions, embargoes, or collective military force can also act as a deterrence against severe crimes. So that's the idea here in generally about why ICC might be important. Uh, Here is some detail about the establishment of the two tribunals, to address these various crimes. And I'll now come to some problems of the ad hoc tribunals. One, it has been argued that the ad hoc tribunals uh, suffered from the problem of selective justice. That is, only individual cases which came to the attention of the Security Council were acted upon. So, and others were let off. Second, funding. They were not a permanent one, so they had to rely on constantly, in a way, to raise funds. So whereas ICC now, through its members, will contribute to its budget and other things. Slow pace of arrest and prosecutions. Again, uh, these tribunals were ad hoc. That means situation by situation, and these war criminals usually have resources to move away from the locations where they committed their crimes. So it was harder to arrest and prosecute, and other aspects about management and administrative difficulties on how to deal with arrested prisoners, um, and such other restrictions. Now, all of these are sought to be ameliorated by having a wider and representative international criminal court. So, if so that all countries are together and they will take, say, steps to arrest anyone who's found, or help each other in prosecutions and gathering evidence, or say, for example, after a person has been convicted by the ICC, they might then take that person and sentence him, and into other countries could step in to have that person serve out a sentence in in their national prisons and things like that. So this will be more global cooperation, and that is where ICC, International Criminal Court, can step in. What are the specific crimes which are within the jurisdiction of the ICC? These are the 4 crimes, which are genocide, crimes against humanity, war crimes, and the crime of aggression. So in the next few slides, we'll be elaborating on all of these and to take a look at it. And but before I go and elaborate on that, I want to highlight one important thing. That is, who will be able to exercise the jurisdiction? That is, if a crime happens, how does the Rome Statute apply? One, if a crime happens in a state party, that is a party which has signed the Rome Statute, they will be subject for scrutiny and inquiry and trial. Second, the Security Council, through the Chapter 7 provisions of the UN Charter, can also refer a matter to the International Criminal Court. Now here it becomes a little bit of a more global one, in the sense that even non-members to the Rome Statute can be subject for prosecution of crimes if it is referred by the Security Council. But we shouldn't worry too much about this in a way, because even before the Rome Statute, the Security Council had such powers, which is the establishment of the ICTY and ICTR. And the third one is the role of a prosecutor in the ICC. And the prosecutor can, by himself or herself, bring a particular problem or a concern to the attention of a pre-trial chamber in the ICC, and say that certain international crimes have happened and that the ICC should look into the matter closely. And this has happened actually very recently with reference to the plight of the Rohingyas in Myanmar. The prosecutor has referred the matter, and incidentally, Myanmar is not a party to the ICC statute, but Bangladesh is. And the Rohingyas are found in exile in Bangladesh, and the prosecutor has taken cognizance of the matter, gathering evidence, and presented to the Security Council. And we have to wait and see what happens as we go forward of the decision of the Myanmar government to persecute the Rohingyas. Certain other jurisdictional facts. One is the ICC is going to complement national jurisdiction. So that means ultimately, if any wrongs happen, the first point of seeking redressal are the national courts. So that is something we should not lose sight of. Second, it will not have any independent enforcement powers. This is similar to other, many other international adjudicatory bodies. They can provide a judgment. They cannot, enforce it. They do not have a police to enforce or something. And third, International Criminal Court will not be retroactive. Simply put, any crimes which have been committed before 2003 cannot be brought under the purview of the ICC. Okay, so that is where certain jurisdiction facts are there. And here are the various elements of the crimes, which is crime of genocide, crime against humanity, war crimes, and crime of aggression. So these slides elaborate what these are. The Article 6 on genocide, it copies the content of the Genocide Convention of 1948, if I'm not wrong, and it is widely accepted about the definition of genocide. Consensus is there, so kind of straightforward. Crimes against humanity, again, this is there have been various elements of it, murder, extermination, enslavement, and others, in which there was more agreement, and this is again clarified here, and is also evolving aspect actually. So that is where rape and more specifically forced pregnancy has become a more recent element of crime in as part of crimes against humanity. similar. This is more detail, and there are a lot of elements. Apartheid, like the one in in South Africa, kind of stands out. And the next one is war crimes. These again have been defined, and the Geneva Conventions act as a basis where grave breaches of the Geneva Conventions on 49 and which are any of the following acts against persons or property protected under the provisions of the relevant Geneva Conventions, willful killing, torture, suffering, and other aspects are going to be uh, uh, implemented as war crimes. So, violation of IHL, use in bello, that is the conduct in the course of a war, will be the subject matters of war crimes. Ethnic cleansing is a matter that was of concern for the international community, especially in the Balkans. So that has again become a focus of defining war crimes. Conscription of children. This is, I think you might have heard about child soldiers. This again is becoming as this has become an important international matter. It has again been criminalized and is now being now declared. So that will be prosecuted too. And the final element of crime, which is crime of aggression. Initially in 2003, this was not agreed upon. The definition was not agreed. And this has been elaborated after the 2010 review conference. And there are certain elements to define something as a crime of aggression. First, the perpetrator must be a political or military leader, so that they are in a position to effectively exercise control over or to direct the political or military action of a state. Then the court also should prove that the perpetrator was involved in planning, preparation, initiation, or execution of such a state of aggression. And also the General Assembly Resolution 3314 serves as a basis, and which points out about the character, gravity, scale, and also a manifest violation of the UN Charter. So, crime of aggression is again a more interesting one, because until the World War II, essentially international community, more specifically, states used war as a means to settle their matters, and it was considered as part of normal politics. But the Nuremberg Tribunal, apart from all other crime against humanity and whatnot, said that Hitler's actions constituted a crime of aggression. And that has become a little bit more, and I think we could think in terms of the concern by the US in 2003 in Iraq, 70s in Vietnam, or Afghanistan, USSR in Afghanistan. All of them could be thought of as meeting the definition of crime of aggression. But henceforth, those countries which initiate war are going to also be subject of scrutiny. And so this is another one that has been put into the definition of the statute. So what is happening with regarding to the ICC? So one, it is starting to provide, the ICC is starting to provide as an alternative to address severe, grave, egregious international violations. So the role of the prosecutor can ameliorate the potential obstruction by the US, say, obstructing through the Security Council. It has even been suggested that that the ICC might be making an opening for the UN Human Rights Court, and of course, one would think there will be no more Security Council ad hoc courts, but that's, I think, open for interpretation. Finally, there is a lot of skepticism about the ICC, and that skepticism arises also from more recent behavior by member states. Some of the states are starting to have concerns, especially countries from Africa, and they have actually started taking steps to get out of ICC, saying that the ICC's caseload and is very biased. Um but uh, it does, I think there is a case to be made that the ICC does respect basic principles by expanding on the Nuremberg aspects, and especially in the changing nature of violence. It also positions provides an independent prosecutor, which I think we generally think is an important aspect of legal adjudication. Provides for an independent court with different judges of different competence, um, and so that's important. Universal applicability, of course, almost, because the ICC cannot apply on non-member states. But remember the point about the Security Council coming to play a role, or the prosecutor, and major atrocities may receive some attention, including the most recent one on Myanmar. Finally, what I wanted to, I think, point out by looking at one of these aspects, which is ICC, is to illustrate an international adjudicatory body and how the international community, from defining international law, agreeing on international law through treaties, states, taking steps through their domestic law, and ultimately, implementation of international law through adjudication. These are the things that I wanted to point out. And all these institutional apparatus, including the ICC and others, provide that international organizational framework to implement law. So that is something to keep in mind, and I wanted to highlight. So this is where the lecture concludes on this particular topic.